I'm sitting in front of letters that we received this week from the United States Army Corps of Engineers. These letters represent an acknowledgement by the Corps of the receipt of a Form 95 that were filed by these same 114,000 individuals. One lawsuit covers the flooding that occurred to the east of the Industrial Canal, and the other lawsuit covers the flooding that occurred on the west of the Industrial Canal. The problem is that instead of acknowledging that these forms have been validly filed, the Corps has sent me a letter saying that it's up to us and me and the individual claimant to determine whether or not the form is valid. Now I know, as they, that in order for the form to be valid, it must contain the name of the person making the claim, it must indicate the damaged property location, it must indicate the amount of money claimed both for property damage and for personal injury or emotional distress, and those two numbers must be added together. Finally, and perhaps most importantly, the form must be signed. You can get this form at www.jbrunolaw.com. You can download it. I've filled out many of the sections for you already. And finally, please keep a copy of whatever you give to the Corps for your records. The only proof that you have that they've received it is what you are going to have. Remember, you're giving it to them, and there's no way to verify that they've got it. They're not going to sign a certified mail receipt or anything like that, and it has to be received, so many of you are going to drop it off at their offices. So please make certain that you have a copy of the form for your records. Every individual, whether you're a business, a corporation, a sole proprietorship, a partnership, every entity, every child, every grandma, mama, has to file their own individual form in order to preserve their claim in this lawsuit. And that form must be received by the United States Army Corps of Engineers before or on August 29th, 2007, which marks the 2-year anniversary of Hurricane Katrina. I know that there's been a lot of confusion caused by the fact that there were two deadlines. The first deadline that everybody heard about was a March 1 deadline, and the other deadline that we've been talking about is the August 29 deadline. Unfortunately for us, the law is that there are two possible bases for this litigation. One I'm generally going to call the Maritime or Admiralty Law, and the other one is the Federal Tort Claims Act. Unfortunately, it's not up to the claimant to decide which of those two acts applies. That's up to the judge. Now, it's further complicated by the fact that under the Admiralty or Maritime Law, the claim has to be filed within 1 year and 6 months of the event. Under the Federal Tort Claims Act, the claim has to be filed within 2 years. So when March 1st came, we urged everybody in an abundance of caution to file the claim form. Now, because we know that there still is a valid claim under the Federal Tort Claims Act, even though the March 1 has passed, we're urging everybody to file a form if you haven't done so in the past. If you filed before March 1st, there's no need for you to file again. The one thing I've got the United States to agree to is to accept the same form as a claim under either the Federal Tort Claims Act or the Maritime Law. Judge Duvall, within a week or two, is going to decide which of those two laws applies to this case.